The Accessibility Breakdown by Inclusion Impact Accessibility.
I am Mark Miller, and this is...
Justin Stockton.
Oh man, that was the best one. Every week, we pay tribute to those who stand out to us as leading by accessibility by picking 3 topics that strike us in some way. This week, we're going to talk about 2 topics that fall under sort of the legal compliance category. This is a little bit deviant for us, but I think there's some really important things to talk about here. So the first one, we're going to talk about this Pharmavite ADA web accessibility class action settlement that's going on. And from there, we're going to go into a legal update. It's called Legal Update May 2026, but it's by Ken Nakata. I don't know if that's how you pronounce it. That's okay, Ken.
I'd say it.
Yep. And then those are going to be our 2 kind of legal ones that we're going to talk about. And, disclaimer, Justin and I are not lawyers, so we're talking about this from the perspective of accessibility consultants and experts. So don't take anything that we cover in this episode as legal advice. And then speaking of legal, if anybody knows her legal stuff, it's Sherry Barnharbor. And I said that wrong, didn't I?
No, I think you got it all right, but there was an odd pause between Sherry.
An odd pause. Sorry, Sherry.
Picked the wrong spot to take a breath.
Just know where Sherry. That hyphenated name throws me off. But anyways, Sherry is an incredible voice in accessibility in general. But one of the many things that makes her incredible is that she has she's a lawyer by trade. So she has the legal component down. However, oddly, that her contribution is completely different. This time around, she wrote this really cool article called "The Faces Age Verification Cannot Read." The Faces Age Verification Cannot Read. So this is a really cool deep dive into this phenomenon that we kind of have going on right now of facial recognition. It's becoming super popular and being used for multiple things, but of course there are things to be considered from an accessibility standpoint that Sherry dives into, and it's kind of a not just a warning, but it highlights some of the issues that we're having currently. So let's get into this class action lawsuit. So this is Pharmavite ADA Web Accessibility Class Action Settlement. The article that we're going to link you out to is written by Danielle Toth. Mm-hmm. And this is a class action lawsuit that involves a handful of companies, Pharmavite LLC, Food State LLC, Pharmavite Direct, and Bonafide Health, all health, pharmaceutical health related. And essentially what the lawsuit is, and one of our reasons, by the way, for diving into this is because, we were thinking about it with all of the Title II, HHS, the extensions that are occurring, and I think that can falsely cause organizations to kind of think that they don't have anything to worry about for a year, right? That's a bit of the danger, and then us who are paying attention to things that are happening, we're like, oh, look at this class action lawsuit and all these other lawsuits and stuff that are still going on. So one, you may be looking at Title II thinking like, oh, this applies to us and this is what we have to worry about. Well, there may be other things you have to worry about too, like Title III, or Section 508 or Section 504 or whatever. So don't just settle on Title II and think that there's a year. You may want to consider how these things affect you overall. But it's not really stopping. And even from that Title II perspective, if you've listened to us in the past, Title II requires that you're accessible right now. The big thing is tying how you do that or demonstrate that to the WCAG 2.1 level AA guidelines. That is sort of the big component to the new rule that was just extended. So anyways, this is just another way that we were looking at this to say that, hey, risk exists out there, and don't become comfortable because you think you have a year necessarily. So this class action lawsuit covers U.S. residents with blindness or visual disabilities that use an assistive technology, which is a fancy way of saying screen reader users, right? And attempted to access, or were deterred from accessing these websites that we just mentioned. The interesting, and this is, I don't know, Justin, if you have any insights here, but I don't know enough about class action settlements and lawsuits or everything, but there's no cash payments. There's literally, like, it's class action, but the cure, I hope I'm using that correctly, is for the company to fix their website, so to make it conformant to WCAG. So I'm not quite sure how that in. I wish Sherry were here. We should have Sherry on as a guest, but I would love an explanation. So if you're listening to this and you have one for us, as to kind of like why a class action suit if it's just if you know what I mean? Does that make sense?
I know that like this idea of a class action suit against a store or some sort of legal entity, having it result in a commitment from that organization to achieve some level of accessibility. It goes all the way back to like the initial Target lawsuit. Like, I don't think that there was any
But was that a
necessarily
class?
any
Was that
money
a class
exchanged
action?
hands. There's no damages. It was, we promise to do better. And
But is that a class action though, or is that just a settlement from a lawsuit?
yeah, I think it could
Because
be
my understanding of class action is it's like, all right, anybody that was affected by this can get a piece of the
it
cure,
can go
whatever
on
it
also.
is. Like everybody gets whatever. I don't know.
Like every once in a while, I get like an email like, "Oh, if you used Verizon Wireless between these dates, you are
Right.
part of a class action lawsuit because they forgot
Yeah.
they didn't do X, Y, or Z."
So, anyways, that's a big. So, if somebody listening knows what that is, we'd love to see that comment. I don't understand why this would be a class action suit in the way that it's structured otherwise. So, I'm sure there's somebody. Sherry, maybe you hear this and you can. We'll have her on as a guest, and she can be like the. What do you call that when you? They would do with news articles where you would put an update on an article. Like if you made a mistake.
Oh, like when you editorialize or when you do like
Or if you made a mistake and you would correct a mistake.
retraction.
I don't know. Maybe I'm thinking of another word. If you know the word I'm trying to think of, maybe you can give that to us as
Two
well.
words, first word sounds like.
They suggest playing charades on a podcast. It usually goes over really, really well. Particularly if people are listening in their cars, that silence when you're doing the charade stuff is great.
Right. Let's just stop talking and we'll go look up the word.
We'll go right. I'll hold for a second. Play music. But anyways, so this is and this of course was brought up by a particular individual. I think that individual actually has a class, a monetary settlement out of it. Again, this is recent, right? This is something that just came up in the past couple of weeks. So demonstrating that, hey, don't just put your feet up and relax. Stuff's happening out there. A couple of other things is that people have until August 13th of this year to object, right? So if you whatever. And then there's a final fairness hearing on September 29th for this. But again, what this group of people has to do is make their website conformant to the WCAG, or websites conformant to the WCAG guidelines. So it's very much in line with the Title II stuff. So
Yeah, in this case, it's 6 different websites that all.
yeah,
that
I know I didn't
all
mention all
underneath
6 of them. I
umbrella.
mentioned 4 of them, but there's 6 of them total. And we'll link you out too, so you can take a look at the case if you want to. All right, do you want to move on to Ken's article, or is there anything else you want to say about the? Okay, so Ken Nakata, in his legal update, talks about some very interesting things, and a lot of these things start to circle around standing, which is a interesting concept in the law if you're not familiar with it. And what's interesting here, and in the way that it relates to this class action lawsuit, is that they're starting to look at these lawsuits that are sort of done by serial plaintiffs. So some of the lawsuits that Ken mentions here, the same law firm and the same plaintiff, so person with a disability, are involved in multiple cases. And there's been some recent backlash where, and to me this is really interesting, Justin, right? There's backlash in where the DOJ and other folks are coming out with these rulings, and these states are coming out with these rulings, and they're like, hey, you can't just, they're trying to control coming in and just throwing lawsuits at companies because they can, and yeah. the extent to which the company can kind of has to react to these. The companies have to react to these things. So, long-winded way of saying there's pushback in this area right now, right?
Well, and it's not just pushback, and this is what Ken talks about in his article, is that there's an existing there was an existing legal decision from years ago, Calcano, or it's referred to as the Calcano decision.
The Calcano, Calcano versus Swarovski?
The Swarovski. The crystals, the little crystals and stuff that you see in, like, I don't know.
No.
Overpriced tourist places. That's what I always think of them as.
But go ahead. You're talking about this precedent.
Yeah, but with Calcano, what he describes, and again, not a lawyer, but I really liked Ken's article because it kind of gave me a little bit more backstory.
Exactly.
Really well written.
It was. You said this earlier before we heated the mics. It was accessible from a little A standpoint, so us folks who are not lawyers could kind of understand how some of this stuff works. So that's why we pulled this article. I would say.
Yeah, but what Calcano did is it said, you can't sue for damages if you don't ever intend to ever revisit that place again. Like, you can't say, like, oh, I was disenfranchised, I was this. If you never intend to go back there, like if it's a place that you depend on and you are and you're barred from entering it, or you're barred from using it, then there's damages, and you've got to be able to have the right to return there. But if someone says, like, oh, I have no intention of ever being there, well, it's kind of hard to, like, award you damages if you never really intend to get there. But then you get into an interesting chicken egg when this decision is applied to accessibility, because then it's, I would return if it was accessible, but if it's not accessible, why would I ever return? And so there's they're starting to apply this kind of legal thought to accessibility, and I get both sides of it. Like, I totally get you at the one way, you don't want the drive-by lawyers to come in and just, like, start randomly suing organizations. At the same time, if those places aren't accessible to someone, who's never going to go?
It's a huge chicken and egg thing. And so just to reel back, so this is what we're talking about. So this, everything Justin just described, is, in my understanding, falls under this category of standing. So in order for a case to move forward, it has to have standing, right? That's why standing is important. So this Calcano ruling standing analysis is rooted in Article 3, which are the injury requirements. So it says that a plaintiff must show a concrete, actual, or imminent injury. So in web accessibility terms, that means what you were saying, Justin, about this real intent to return and complete a transaction. So in some of these physical terms, one of the other things that starts to become, and this is, I think this was in the Mercedes versus Restaurant Management Inc. This came about, is that it can't be, according to this, it can't be like, I was thinking about showing up again someday.
Yeah.
But that's where the chicken and egg comes in. It's like, well, yeah, you were thinking about showing up again someday, and if it's not going to be accessible, you're probably not going to show up. And I think that also shows up in. Let me look this up. It was the one Sears and somebody, Fezor, Fezor versus Sears, but it. So one of the reasons why they lost standing was because they kind of said that they were like, yeah, we're thinking about showing up again one day. It was kind of this. And the argument was that there wasn't a clear, to your point, like they didn't have to show up, and there wasn't a clear intent. Like, we're coming back on Thursday
Right.
to try and do this again because it's so important. It was like, well, we'd show up if it were accessible. So that's where that standing argument, or that's the precedent that these standing arguments are leaning on. And again, it's hard to pull it apart. Like, is that really truly, like, it makes sense on one hand, and then on the other hand, it's like, yeah, but we know from being in this industry, lots of times the reasons why people with disabilities are kind of wishy-washy, for a better term, about what they're going to do is because of the lack of accessibility in the first place. So it's almost like the opportunity to create real reasons to show up, or to have that be the place that you buy your X, Y, or Z, whatever the case might be. There's not an equal opportunity for that to develop. And so it's just, in my opinion, it's very interesting. And if you're kind of scratching your head over this and you're wondering, read Ken's article, because I think it really does outline this to the lay person in a way that makes you think about it. And I'm a both sides person. I try to understand both sides instead of just being like, I'm an accessibility guy. Let's get, I should lean on this way or that way.
Yeah, well, I have to understand both sides, because in order for me to it's Sun Tzu. It's in order for me to defend my side, I have to know how the other side
thinks. Yeah,
how they're thinking. What arguments are they making?
Yeah.
So I advocate for everyone making the web inclusive and accessible to everyone. So, but I understand from a legal perspective, we have these existing decisions that some courts may use, some courts may not, based on all of the circuit courts and all that, that information. But that's another thing I need to look into.
Well, this falls under the Ninth Circuit. All these cases, I believe, fall under
or the Ninth.
We're in the Ninth Circuit, and to give you an idea of the Ninth Circuit, that covers Alaska, Arizona, California, Hawaii, Idaho, Montana, Nevada, Oregon, and Washington. And so the Calcano is pervasive in the Ninth Circuit.
No, Calcano is actually in the Second Circuit. I remember that from Ken's article, because it's just now starting to be used. It's starting to be referenced in California, in some of the California cases which fall in the Ninth. But it was actually, Calcano was from the Second Circuit.
But I think the point is that it wasn't very persuasive in the Second Circuit for some reason. And now it's persuasive in the Ninth Circuit. So there's also this Fraser versus Sears, which backs it up. Anyways, again, we're a bit out of our depth trying to pull this apart. But thanks to Ken, it's a little bit more clear how all these nuanced things work. The other thing I just want to say about standing, I love analogies, right? And I was looking at standing, and one of the things that I thought of is it's like the calling BS of the legal world, right? That's what standing is. So it's like, oh, damages and I've suffered, and standing is there to be like, I'm calling BS. Like you live 5 hours away from that. I don't think you ever tried to show up and suffered, So it's a way to kind of be like, let's get real here. Now, whether or not that works out well in every circumstance is arguable, but
well, how do you do that for digital property?
It's so hard with it's so hard with digital property. But anyways, that's what went through my mind when I was like digging into this. I'm like, it's just the ability to call BS like right away. on the lawsuit. I mean, I guess that's what the lawsuit is, like arguing the lawsuit, or the defendant side of the lawsuit is calling BS on it in general. But this is like a quick look into that. All right. For fear of butchering the legal stuff any further than we already have.
I do
Thanks,
want to
Ken.
say one of the
I
other
just want to
things that I
say
like.
thanks, Ken, for at least bringing us this far along with the legal stuff. And Sherry, I think we need you on the next discussion. But is there anything else you want to add before we move on?
Well, I do want to say one of the cool things that I liked about. So we pulled this the snippet that we kind of talked about here was really out of their this newsletter that Ken does, I think once a month or so. At least this one was May 2026, but it was a legal update. And we all love
Yeah.
Lainey Feingold's update at CSUN, and we pay attention to it. But there was a legal update. He has a bill tracker on his
Oh, that's right.
update. And I
Yeah.
thought that was really cool because he's giving you updates on some of the bills that are moving both at the federal level, but also some of the individual states. So I was very excited to see Colorado mentioned in the list there, and that Colorado just passed and signed at the end of May a new law that requires the insertion of the language for vendor to hold vendors liable for inaccessible IT sold to public schools. So what's cool about that is that even if
Yeah.
the actual contract did not specifically call out the requirement for accessibility, that it's in by default, as well as like security and some other aspects. So it's always there, it's always underlined, even if it's not specifically called out, and it's going to hold vendors liable.
Yep.
That's really cool.
That's a really good point, and I remember seeing that bill. It was a cool thing. So, just a little more about Ken. He's Converge accessibility, like really good, reputable accessibility consultant in his own right. So we'll link you to his page, but just so that you know who he is. And I think that the quality of his work is apparent by the content that he puts out.
Yeah.
Like, it's very thoughtful, useful content, right? So we appreciate that. We aspire to do the same thing ourselves. But check out this article for sure, and in doing that, you'll be led to his website. You can check out Ken in general. All right, you want to talk about? Are you good?
Yeah,
Are you
yeah,
good with
good.
your stuff? Yeah. Okay. So let's talk about Sherry's article.
Sure.
And so this was interesting. So the name of the article is, I got to be careful how I read this because it sounds funny if you don't read it in the right cadence, but it sounds
Put a
perfect.
comma after faces.
I think that's right. The faces age verification cannot read. The faces age verification cannot read. So that, just in the title, you can kind of understand where Sherry's going with this, and that is that we have this facial recognition software. We're starting to rely on it so much. She points out, her exact words in the article is that facial recognition and age verification are having a moment, right? Which I agree with, because it's everything. My phone, everything is like, do you want to recognize by your face? And I'm like, I'm good. Like, I actually kind of like typing in the like I've got a 4-digit code I type in, and I like that. Although my phone does recognize my face, so I shouldn't complain too much about it.
That's on device though. This
It's
is
on device. It's different. Yeah. But the point is it's kind of everywhere now, right? It's everywhere now. But that people for all sorts of reasons, and Sherry goes into them, but that these are trained on, the software is trained on faces that don't necessarily represent disabilities.
Yeah.
So in the really interesting point, and this is what kind of caught me and was like the learning moment for me here too, is that one of the big problems is that we're starting to use this for age verification, and certain disabilities and other things can really flip-flop. It can make a young face look very old or an old face look very young. So now if you're relying on that as the age verification in one direction or another, there's a good chance that you're going to get it wrong.
Yeah.
And that's kind of the first.
Or the third case that she mentions is that it may not be able to determine either way. And when you go to try to resolve that issue, the people on the other end that are trying to maybe like manually resolve this in some way or trying to figure out what to do next have not been trained on how to handle these types of situations.
Right.
You also have to do it. There's also cases where, like take Roblox. My 8-year-old loves Roblox and it drives me nuts. But the age verification is built into there. And so you might have a kid who's just trying to.
Is that a facial?
Yes.
Okay. All right.
Yeah. This is why I really like, it really freaks me out. Like there's the accessibility side of it, but there's a security aspect of this like we should not be taking pictures of kids' faces and storing them in centralized locations. Like that's just a disaster waiting to happen.
But so I'm assuming the age verification on that is to keep people who are older and maybe have nefarious intentions out of it. Yes?
Yes.
So what's stopping me from having a picture of a kid on a tablet and holding that up to my...
Well,
it seems
when
too
you do
easy.
the age verification, you have to do a 3D scan. So we opted my son out. I did the age verification. So there can be two parts to the age verification. Like as a child, you can try to do the age verification to say, I am a child and I want to identify as a child, in which case the points that Sherry brings up in her article apply. Someone could appear much younger or they could appear much older. But two, in order for an adult to do the approval, the adult has to go through. So maybe the adult has some sort of facial features that make them appear older or younger or whatever.
Right.
So you can really kind of, for when kids are involved in this type of thing, like with an app like Roblox, you kind of get the double whammy, or you have the potential for the double whammy.
Double whammy.
And it's not great. But really, we should not be doing face-based age verification at all. Like,
I think that the
bad idea.
Yeah, and I think that so in reading this article, it wasn't like Sherry came up and said like all this stuff and then here's the answer, right? I think that the intent was we need to keep exploring.
Yes.
Right? That we can't just fall back on this and be like, this is the way it is. Not only because of the problems that exist with facial recognition, but also because the current alternatives are not accessible. And this is creating legal and privacy risks on top of it. So you may look at it and go like, okay, well, I don't have to use face recognition. I can use my pen code. I can use this. And that's all well and good, but that all needs to be accessible as well. So we need to continue to explore ways of doing this important verification. Right? Age verification is important for all the reasons that we just talked about, right? Which is why it can't settle where it is right now. And it needs to be explored further, and it needs to be made accessible to people with disabilities. And we need to make sure that we're considering the way that faces may not be what we, like I said, the faces that these were trained on are the faces that you would consider to be, in air quotes, average or whatever, aren't representative of everybody, and so it's problematic.
Yeah. Well, I don't know. If you put on your bad actor hat, then it's probably even possible that a bad actor who wants to gain access could use one of the loopholes
100%
of an inaccessible face scanning to identify as someone or an age that they're not supposed to be.
And I think the thing that we're talking about here is that we've all watched these spy movies for years where the cool secure tech was biometrics, right?
Right.
It's like, like you get in there and you're like, I need a thumbprint, I need a handprint, I need, to scan my face. And the Hollywood answer has been cut off the guy's finger or go through this complicated process. I think even one of the Missions Impossible did it, where like they took a mold of the face, like all this stuff, and it's like, actually, it's not that hard, right?
Yeah.
Like a lot of fingerprint stuff is, you just need the person's fingerprint, and then you can take that, lift it, and use that to get past that biometric. Pictures of faces have been used easily. My favorite is when the person is like, knocked out cold and they just hold the phone up to their face. Right?
Oh yeah, you see that on Instagram all the time. Like the little kid, like don't want some more screen time, just holds it up to like their mom's sleeping.
Mom's face while she's sleeping or whatever. But if you go back to like the 4-digit pin, you can cut my fingers off. You can hold it up to my sleeping face. You can knock me out. The pin's harder to get. You know what I mean? So it's this default too, that because it's a biometric, that is somehow more secure, and that's Hollywood, man. Yeah. It's not necessarily more secure, and in fact, can be difficult to use.
I get why we definitely need a way to determine age on the internet. There are bad pockets of the 100%. Internet, believe it or not, and there are places where kids should be able to go on the internet and be able to have a safe place. There are also places on the internet we don't want kids to go. Yes. But scanning faces to determine age, that's a bad place to be.
So anyways, you did it again, Sherry. I think this was a really interesting sort of, I wouldn't have stopped and thought about it myself. So I was really glad to have this surfaced and explored. And I do like Sherry's ability to say, like, I'm not saying I've got an answer here. I'm saying we should be paying attention to this more so that we can come up with better answers along the way. I mean, the answer being, let's not settle for this, right?
I do like the way that Sherry writes too, because like the first 50% of her article, like, you feel like, yeah, you got your pitchfork out, you're ready to take charge. And then like she kind of like steps down a little bit and brings in that reason of why, like, here's some of the things that we need to think about, some of the nuance and things, even though I've already got my pitchfork at the ready from the first half of the article.
No, Sherry is very skilled in breaking an argument down and looking at it from all those angles and truly invoking thought about it and having a little fun, right? Making sure she writes in a way that causes Justin to get out his pitchfork before he's finished with the article, so that we can all go, all right, Justin, put it down, relax.
I got my pitchfork. I didn't read the second half of the article.
Just don't take off with your pitchfork until you read the whole article. That's the
right.
That's the thing. All right, man. Anything else you want to cover on this?
No. That was a good session. Good articles.
Yep. Lots of thinking. Did lots of thinking on these from angles that I wasn't normally thinking from. So I appreciate both Ken and Sherry for putting out content that kind of makes us think in ways that we weren't thinking in before.
Yeah.
Now that we have broken accessibility down for you, we hope you go forth and keep it accessible.
Thank you for listening to the Accessibility Breakdown by Inclusion Impact Accessibility.